Good morning, students. I am Bharati, your commerce teacher. Today we are going to see about Unit 8, the Sale of Goods Act 1930 and the Negotiable Instruments Act 1881. Chapter 21, the Sale of Goods Act 1930. Students, before starting the class, we are going to recall the last session. In the last session, we can saw about chapter 20. Title of the chapter is Liberalization, Privatization and Globalization. Under the topic, three dimensions of new economic policy, meaning and forms of LPG. LPG means liberalization, privatization and globalization. And what are the merits and demerits of LPG? Then impact of LPG. So all those topics are completed in previous session. Now we can discuss about today's topic, Unit 8, the Sale of Goods Act 1930 and the Negotiable Instruments Act 1881. So chapter 21, the Sale of Goods Act 1930. Under the topic, the synopsis of the chapter, introduction, formation, essentials of contract of sale, difference between sale and agreement to sell, what are the different types of goods, transfer of ownership, conditions and warranties, implied conditions and implied warranties, then finally unpaid sellers and rights of unpaid seller. What are the rights of unpaid seller and a buyer? So these are about topics will be discussed in this class. First we can see about introduction of sale of goods. So one of the special contracts period chapter 7 of Indian Contract Act, general principles of Contract Act are applicable to contract of sale of goods. So what do you mean by contract of sale of goods? Contract of sale of goods is a contract whereby the seller transfer or agrees to transfer the property, that is a ownership of the goods, to the buyer for a price. Then what is the formation of contract of sale of goods? Contract of sale of goods is contract whereby the seller transfers or agrees to transfer of property, that is a property means ownership of the goods for a price. Ownership and possession, mere possession is not sale. Purchase means buying the ownership in the goods from seller for a price. Unlimited rights against the entire world. Absolute ownership, unlimited rights. So this is a formation of sale of goods. Then what are the essentials elements of COS? Contract of sale. Contract of sale. Okay, COS means contract of sale. Okay, there are two parties. The following are essentials elements of a contract of sale. Two parties, transfer of property, goods, price, then includes both sale and agreement to sell. So first, two parties, different person. Two parties means different person. One person is dissolution of partnership, that is a distribution of assets, not a sale. Partners or joint owners of the assets of the firm. There are two parties. Exception, when goods of a persons are sold in executions of a degree, he himself may buy the goods to retain their ownership. Then second one, transfer of property. Then third one, goods. The goods means its subject matter must be goods. Excludes money, actionable claims, immovable properties. Immovable properties means intangible assets. Intangible assets. Then includes every kind of movable property. Movable properties means intangible assets. Immovable properties means fixed assets. The stocks and shares, growing crops, etc. For example, goodwill, trademarks, copyrights, patent rights, etc. are also regarded as the goods of example of movable property. Movable properties is otherwise known as intangible assets. Then price. The monetary considerations for the goods sold is called price. So partly by goods and partly money, the contract is sale. Partly means any one of the part you have to be paid or fixing the price. The monetary considerations for the goods sold is called price. What in by goods first? What in by goods? The term goods includes every kind of movable property, stocks and shares, growing crops, etc. Goodwill, trademarks, then copyrights, patent rights, etc. and are also regarded as goods. It means goods in சொல்றது பாருங்க. Topic first topic பாருங்க. The includes இருக்குல்லையா? This is mean by a goods. Then finally includes both sale and agreement to sell. Sale and agreement to sell. They includes both sale and agreement to sell. If the property in the goods is transferred immediately to the buyer, it is known as sale. If the transfer of property is to take place at a future date or on fulfillment of certain conditions, it is known as agreement to sell. What in by sale? Immediately the goods is transferred to the buyer. What in by agreement to sell? If the transfer of properties take place at a future date or on fulfillment of certain conditions, it is known as the agreement to sell. So wherever the goods under the agreement to sell are destroyed, the loss fails squarely on the sellers as the ownership is still vested with the seller, even though the positions of the goods is with the buyer. Then next one topic, sale and agreement to sell. Sale and agreement to sell. What are the difference between sale and agreement to sell? First one, ownership transfer. The property, ownership or title in the goods passes from the seller to the buyer immediately, so that the seller is no more owner. So immediately என்ன பண்ணணும், நம்ம ஓனர்ஷிப்பை ட்ரான்ஸ்ஃபர் பண்ணோம். பட் அக்ரிமெண்ட் டு சேல் வந்து பார்த்தீங்கன்னா at a future time of on fulfillment some conditions, and fulfillment of some condition, the property that is a ownership or title in the goods has to pass at a future time or after the fulfillment of certain conditions specified in the contract. The second one, risk of loss. In the sale, where the goods sold under the contract of sale are destroyed, the loss falls squarely on the buyer, as the ownership in the goods has already passed on to the latter, even though the goods are in the positions of seller. So on the buyer as the ownership has already passed to buyer. But agreement to sale, so where the goods under the agreement to sale are destroyed, the loss falls squarely and the seller as the ownership is still vested with the seller, even though the positions of the goods is with the buyer. So on the seller as ownership is still vested with the seller, it is known as the agreement to sell. This is the risk of loss. Then third one, consequence of violating the contract. So where the buyer fails to pay the price, the seller cannot seize the goods. Seize means forfeited the goods. அதாவது சீஸ் பண்ணணும்னா அவங்க கிட்ட இருந்து பறிமுதல் பண்ணக்கூடாது அப்படின்னு சொல்கிறாங்க. தென் சேல், கான்சிக்வன்சஸ் ஆஃப் வயலேட்டிங் த கான்ட்ராக்ட். சேல் மீன்ஸ் வேர் த பையர் ஃபெயில்ஸ் டு பே, டியூ மணி கட்ட தவறிட்டாங்க அப்படின்னு சொன்னால், ஃபெயில்ஸ் டு பே த ப்ரைஸ், த செல்லர் கேனாட் சீஸ் த குட்ஸ். உடனே என்ன பண்ணக்கூடாது, செல்லர் கஸ்டமர்கிட்டருந்து பையர்கிட்டருந்து அவர் குட்ஸை பறிமுதல் பண்ணக்கூடாது. த செல்லர்ஸ் கேன் ஒன்லி ஃபைல் எ கேஸ். கேஸ் மட்டும் நீங்கள் என்ன பண்ண அகைன்ஸ்டாக அவருக்கு அகைன்ஸ்டாக பையருக்கு அகைன்ஸ்டாக ஃபைல் பண்ணிக்கலாம். பட் அவர்கிட்ட வந்து குட்ஸ் என்ன பண்ணக்கூடாது, நீங்கள் வந்து உங்களுடைய இஷ்டத்துக்கு forfeit பண்ணக்கூடாதுன்னு சொல்கிறாங்க. The sellers can only file a case against the buyer for violating the contract. But agreement to sell, where the buyer violates the contract, the seller can repossess the goods from the farmer. He can sue for damages for violation of the contract. Then next one topic, இன்சால்வன்சி ஆஃப் த பையர். இன்சால்வன்சி அப்படின்னா அவர் வந்து நொடிப்பு நிலை அடைந்தார். ஸோ அன்ஃபிட் பர்சனாக ஆயிடுறாரு. அவரால் வந்து ரொம்ப லாங் டைம் வந்து ஸ்டாண்ட் பண்ணி எதுவுமே ஒர்க் பண்ண முடியாது, எதையும் கரெக்டாக ப்ராப்பராக அவரால் செய்ய முடியாத ஒரு சுச்சுவேஷன், அன்கண்டிஷனில் இருக்கக்கூடிய பர்சன்ஸ் போய் தான் நம்ம என்னென்னு சொல்கிறோம், இன்சால்வன்சி பர்சன் சொல்கிறோம். ஓகே, இன்சால்வன்சி ஆஃப் த பையர். சப்போஸ் இன் கேஸ் பர்சன்ஸ் வந்து அந்த பையர் வந்து வாங்கின பையர் என்ன ஆகிடுச்சுன்னா ஒரு ஆக்சிடென்ட் ஆலையோ இல்லை ஏதோ ஒரு அவரோட மைண்ட் டிப்ரெஷன் ஆகியோ ஏதோ ஒரு என்ன ஆகிடுச்சுன்னா ஒரு அன்ஃபிட் பர்சனாக ஆகிட்டார். அவரால் முடியாத ஒரு கண்டிஷன்ஸ், அன்கண்டிஷனில் இருக்கக்கூடிய ஒரு பர்சன். அப்போ த சேல், இட் இஸ் இன் எ சேல் இஃப் எ பையர் பிகம்ஸ் insolvent before the pays for the goods, even though the goods sold are under the possessions of the seller, the latter has to return them to the official receiver or assignee as the ownership of goods has already been transferred to the buyer. So if the agreement to sell, if the buyer becomes insolvent before the payment of the price, the seller can retain the goods if they are under his possessions, or even he can repossess the goods even if the possessions of the goods is transferred to the buyer. Then insolvency of the செல்லர். இப்போ நம்ம பையர் பார்த்தோம், இப்போ இன்சால்வன்சி ஆஃப், இப்போ சப்போஸ் இன் கேஸு இப்போ பையர் வந்து நொடிப்புணி அடைஞ்சிட்டா எப்படி வந்து அவர்கிட்ட கொடுத்த குட்ஸுக்கான அமௌண்ட்டை நம்மளோட இதுக்கு ட்ரான்ஸ்ஃபர் பண்ணுறதுன்னு பார்த்தோம். இப்போ செல்லர் இன் சேம் டைம் செல்லர் வந்து இன்சால்வன்சி ஆகிட்டார் அப்படின்னா இன்சால்வன்சி ஆஃப் த செல்லர். ஸோ வாட் ஆர் த எக்ஸிக்யூட்டரி அப்படின்னு நம்ம பார்க்கும்போது, இஃப் த செல்லர் பிகாஸ் insolvent before delivering the goods to the buyer can claim delivery from the official receiver or assignee. The buyer cannot agreement to sell பார்த்தீங்கன்னா the buyer cannot do so if the buyer has paid the price advance he can claim only retable dividend and not the goods. So because ownership is not yet ட்ரான்ஸ்ஃபர், ஓனர்ஷிப் மாற்ற மாட்டாங்க, பட் டிவிடெண்ட் வரும்போது அதுலேருந்து அவங்க என்ன பண்ணிப்பாங்க, அந்த லாபத்தொகை வரும்போது அவங்க அந்த ஷேரை எடுத்துக்குவாங்க. பட் ஓனர்ஷிப் என்ன பண்ண மாட்டாங்க, இமீடியட்டாக ட்ரான்ஸ்ஃபர் பண்ணிக்க மாட்டாங்க. நாட் எட் ட்ரான்ஸ்ஃபர்டு. ஸோ தீஸ் ஆர் ஆல் த டிஃப்ரென்ஸ் பிட்வீன் சேல் அண்டு அக்ரிமெண்ட் டு செல். The next topic, what are the types of goods? So under the types of goods classified as, the first one, goods, every kind of movable goods other than actionable claims. Then first actionable claim means debt secured by a mortgage of immovable property, fixed deposit receipts, dividend due on shares amount, then dues under LIC policy, claim for rent which falls due in future, etc. This is actionable claims. Then goods, shares, stock, growing crops, grass, thing attached to the land and forming part of land agreed to be cut off from the land before sale. Goodwill, copyright, trademark. Goodwill means get the good name of the firm or any institution. Then copyright, trademark, patent, water, gas, electricity, power, etc. இந்த குட்ஸ் எல்லாமே கண்டிப்பாக மூவபிள் ஆக்கிட்டே தான் இருக்கும். தட் இஸ் ஏ மூவபிள் ப்ராப்பர்ட்டிக்கு வந்து நமக்கு என்ன சொல்கிறோம், எக்ஸாம்பிள்ஸ் தான் நம்ம இதெல்லாம் சொல்கிறோம். ஓகேங்களா. தென் what are the classification of goods? Under the Sale of Goods Act, the goods classified as follows. The first one is existing goods, then second one contingent goods, then third one future goods. First we can see the existing goods. What are existing goods? So goods that are owned or possessed by the seller at the time of contract. Then specific goods identified and agreed upon at the time of sale. There are three types of existing நம்ம goods வந்து டிவைட் பண்ணுறாங்க. should be divided into three types of existing goods. One is specific goods, ascertaining goods, then genetic or unascertaining goods. What do you mean by existing goods? Existing goods are those owned or possessed by the seller at the time of contract of sale. Goods possessed even refer to sale by agents or by pledgers. Pledgerனா யார் அடமானம் வைக்கிறாங்களோ அவங்க அடகு வைக்கிறவங்கள தான் நம்ம என்ன சொல்கிறோம், pledger சொல்கிறோம். Existing goods may be either specific goods, ascertaining goods, genetic or uncertain goods. First, then second one type of sale of goods is contingent goods. The first one பாருங்க, specific goods சொன்னோம் இல்லையா. Specific goods means identified and agreed upon at the time of sale. Then uncertain goods or genetic goods not identified and agreed at the time of sale. Then ascertain goods similar to specific goods, but the term may even refer to the goods which become ascertain subsequent means followed by the previous year to the formations of contract. Then future goods. இப்போ நம்ம என்ன பார்த்தோம், contingent goods பார்த்தோம். இங்கே பாருங்க, contingent second one என்னது, contingent goods. Contingent goods means what? Contingent goods are the goods the actions of which by the seller depends upon a contingency. So contingent goods are a part of future goods. For example, he agrees to sell a particular painting work provided he gets from C. In this case, the painting work represents contingent goods. Similarly, a rice merchant agrees to supply 10 bags of basmati rice from Pakistan if he gets supplies. In this case, basmati rice representing contingent goods may or may not be available to the rice merchant. So this is a contingent goods. Contingent goods means are a part of future goods. Contingent goods means are part of a future goods. Then next one, future goods. These goods good which a seller does not possess at the time of contract of sale, but which will be manufactured or produced or acquired by him after entering into the contract of sale agreement. So for example, yes, a contractor agrees to supply 100 bags of rice to B for giving marriage feast. It is a case of future goods. So similarly, where the bus company agrees to buy spare parts from a particular supplier, it is an example of future contract. So future goods represents unascertained goods. The seller does not possess at the time of COS, contract of sale, will be manufactured or acquired after entering into contract of sale. So future goods represents unascertained goods. For example, seller will buy and supply. ஸோ நம்ம கண்டிஜென்ஸ் கொடுத்தா இப்போ நம்ம பார்த்தோம் செகண்ட் ஒன்று. வாட் இஸ் கண்டிஜென்ட் கூட்ஸ்? கூட்ஸ் ஆக்ஷன்ஸ் acquisitions of which by the seller depends upon a contract contingency. It is a event which may or may not happen. An event which may or may not be happen. They are part of future goods. They are part of future goods. Contingent goods means what? The contingent goods are the goods, the acquisitions of which by the seller depends upon a contingency. Contingent goods are a part of the future goods. So these are the different types of classifications of goods. Then the next topic, transfer of ownership. Transfer of ownership. Transfer of ownership or transfer of property is main object of COS, contract of sale. What are the main aim of contract of sale? Transfer of ownership or transfer of property. உரிமையாளருடைய உரிமைகளை மாற்றணும், அப்படி இல்லைன்னா ப்ராப்பர்ட்டினா அவருடைய சொத்துக்கள் எல்லாத்தையுமே நம்ம என்ன பண்ணணும், ட்ரான்ஸ்ஃபர் பண்ணணும் அப்படின்னு சொல்கிறாங்க. ஓகே, தென் செகண்ட் ஒன், ட்ரான்ஸ்ஃபர் ஆஃப் ஓனர்ஷிப் இஸ் ட்ரான்ஸ்ஃபர் ஆஃப் ப்ராப்பர்ட்டி இன் த குட்ஸ். Then transfer of title in the property means passing of property. Then property in goods means custody and control. அவங்களுடைய கஸ்டடியில் இருக்கிறது, அவங்களுடைய ஃபுல் கண்ட்ரோலில் இருக்கிறது, அவங்களுடைய கட்டுப்பாட்டுக்குள்ளே அவங்களுடைய ஃபுல் கண்ட்ரோலில் இருக்கிறது நம்ம என்ன பண்ணணும், கண்டிப்பாக ட்ரான்ஸ்ஃபர் பண்ணணும்னு சொல்கிறாங்க. ஸோ டைம் ஆஃப் ட்ரான்ஸ்ஃபர் டிபெண்ட்ஸ் அப்பான் த நேச்சர் ஆஃப் குட்ஸ். எதை டிபெண்ட் பண்ணியிருக்காங்க, மெயினாக டிபெண்ட்ஸ் அப்பான் த நேச்சர் ஆஃப் குட்ஸ். First one, specific goods. First one, specific goods. இப்போ நம்ம என்ன டாபிக் பார்த்துருக்கணும், வாட் ஆர் த டாபிக், வாட் ஆர் த டிஃப்ரென்ஸ் பிட்வீன் ஸ்பெசிஃபிக் குட்ஸ், அசர்டைன் குட்ஸ் அண்ட் அன்அசர்டைன் குட்ஸ் நம்ம இப்போ பார்க்க போகிறோம். த ஃபர்ஸ்ட் ஒன் இஸ் ஸ்பெசிஃபிக் குட்ஸ். At the time of contract, where there is an unconditional contract of the sale of specific goods in a deliverable state, ownership in the goods passes to the buyer when the contract of sale is made. The time of payment of price of time of delivery of goods is immaterial. It is known as the time of at the time of contract. This is specific goods, one of the specific goods. Then second one, beyond the date of contract. Beyond the date of contract. First one, goods not in deliverable state, where there is a contract of sale of specific goods not in a deliverable condition. The ownership does not pass till such activities bringing them into deliverable conditions are completed. It is known as the goods not in deliverable state. This is a beyond the date of contract. Then second one, when the price of goods is to be ascertained by weighing or testing or doing something, where there is contract of sale of specific goods in a deliverable condition, but the seller is yet to weight, measures, test or do some other act or thing with reference to the goods for the purpose of fixing the price. Then the ownership in the goods passes to the buyer only after such activities are carried out and completed and the buyer has knowledge of it. Then second one, unascertained goods. Unascertained goods. நம்ம மேலே பார்த்தது அசர்டைன் குட்ஸ்னு சொல்கிறோம். தென் செகண்ட் வந்து பார்த்தீங்கன்னா அன்அசர்டைன். ஃபர்ஸ்ட் ஸ்பெசிஃபிக் குட்ஸு, தென் செகண்ட் ஒன் அன்அசர்டைன் குட்ஸ் ஆர் genetic goods. The first one, what in by unascertained goods? So these goods which are not identified and agreed upon the time of contract of sale. For example, wants to buy a car from a showroom where different models. Wants to buy a car from a showroom where different models at different prices have been displayed. All these displayed models represents unascertained goods. So ascertainment is the process by which the goods to be delivered under the contract of sale are identified and set apart. It is a unilateral act of the seller alone to identify and isolate the goods. When goods are appropriate to the contract. Appropriation is a process by which the goods to be delivered under the contract of sale are identified and isolated with the consent of the seller as well as the buyer. It is a bilateral act of the seller as well as buyer, where goods identified and isolated are put into boxes or any container with the consent of the buyer. It is called appropriation. Then delivery to the carrier, where the seller delivers the goods to a carrier for the purpose of transportation to the buyer. He is deemed to have unconditionally appropriate the goods to the contract, but the only condition is that the seller should not have reserved the right of disposal of the goods. This is delivered to the carrier. Then goods sent on approval or on sale or on return. Goods sent on approval or on sale or on return basis. It means that the buyer has the option either to return or retain the goods. Then next one topic is conditions and warranties. Conditions and warranties. First one, condition. A conditions in a contract of sale with reference to goods may be a conditions or warranty. What in by condition? A condition is a stipulation which is essential to the main purpose of the contract. Main purpose of the contract. Then it is the core to the contract. Non-fulfillment of the conditions cancels the very contract. If the conditions is broken, it leads to cancellation of the contract. Then warranty. What in by warranty? It is a stipulation which is collateral to the main purpose of the contract. It is of secondary importance. The violations of warranty entitles the affected party to claim damages or compensation from the other party. The affected party cannot cancel the contract altogether. A stipulation or condition is contract specific. This is a warranty. Then next topic, we can go to next topic. See the next topic. What are the difference between condition and warranty? What are the difference between condition and warranty? First one, meaning. What do you mean by condition and what do you mean by warranty? Condition means it is a stipulation which is essential to the main purpose of the contract of sale. Essential to main purpose of the sale. Warranty means it is a stipulation which is collateral to the main purpose of contract. Collateral to the main purpose of contract. Main purpose of contract. Then significance. What are the significance of condition? Conditions is so essential to the contract that the breaking of which cancels out the contract. That is essential to contract. If broken contract is cancelled. Okay. Then warranty, subsidiary or inferior violation will not revoke the contract. That is, it is of subsidiary or inferior character. The violations of warranty will not revoke the contract. Then transfer of ownership. What are the condition of transfer of ownership? Ownership on goods cannot be transferred without fulfilling the condition. But warranty, ownership on goods can be transferred on the buyer without fulfilling the warranty. The next one, remedy. Remedy. In the case of breach of contract, the affected party can cancel the contract and claim damages of the condition. Then warranty. In the case of breach of warranty, the affected party cannot cancel the contract but can claim damages only. The last one, treatment. Breach of conditions may be treated as breach of warranty. Then breach of warranty cannot be treated as breach of conditions of condition. இங்கே பாருங்க, the first one treatment-க்கு breach of contract may be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. Okay, so these are all the difference between conditions and warranty. Then we can go to next topic. What are the implied conditions? Conditions as to title, seller has a right to sell the goods. Then second one, condition as to description. In a contract of sale, by description, there is an implied condition that the goods supplied should agree with the descriptions made by the seller. Then third one, sale by sample. Sampleனா அது என்ன சொல்கிறது, இப்போ நம்ம ஒரு பொருள் யூஸ் பண்ணுறதுக்கு முன்னாடி அதை வந்து நம்ம வாங்கி அதை கன்சப்ஷன் பண்ணுறோம், அதுதான் நம்ம சாம்பிள் பீஸ்ன்னு சொல்கிறோம். வேர் குட்ஸ் ஆர் sold by showing samples, the bulk of goods supplied should be similar to the sample shown. ஒரு பல்காக நம்ம குட்ஸை வந்து நம்ம சேல் பண்ணுறோன்னா அதுக்கு முன்னாடி அந்த பொருளை வாங்கி நம்ம டேஸ்ட் பண்ணி பார்க்கணும். தட் இஸ் சாம்பிள் பீஸ், எக்ஸாம்பிள். அது ஒரு மாதிரி படிவோம் அப்படின்னு சொல்கிறாங்க. அந்த சாம்பிள் பீஸை இப்போ ஒரு ஃப்ரூட்ஸ் கடைக்கு நம்ம போகிறோம். அந்த ஃப்ரூட்ஸை நம்ம என்ன பண்ணுறோம், கிரேப்ஸ் நல்லா இருக்கா அப்படின்னா ஒரு பீஸ் எடுத்து சாப்பிட்டு பாருங்கள், டேஸ்ட் பண்ணி பாருங்கள் அப்படின்னு சொல்கிறாரு செல்லர். உடனே பையர் என்ன பண்ணுறாரு, ஒரு பீஸ் எடுத்து சாப்பிட்டு பார்த்த உடனே டேஸ்ட் பண்ணோடனே ரொம்ப டேஸ்டியாக இருந்துச்சுன்னு சொன்னால் ஓகே எனக்கு 1 kg கொடுங்க அப்படின்னு நம்ம கேட்கலையே. அப்போ நம்ம இந்த பல்காக வாங்குறதுக்கு முன்னாடி அதை நம்ம என்ன பண்ணுறோம், பிஃபோர் டெஸ்டிங் த குட்ஸ். அப்போதுக்கப்புறம் தான் ஆஃப்டர் டெஸ்டிங் த குட்ஸ் நம்ம என்ன பண்ணுறோம், பர்ச்சேஸ் ஆஃப், அதாவது குட்ஸ் வந்து பல்காக நம்ம என்ன பண்ணுறோம், பர்ச்சேஸ் பண்ணுறோம். ஓகேங்களா, திஸ் இஸ் சாம்பிள், சேல் பை சாம்பிள். Then fourth one, conditions unto quality or fitness. There is no implied condition as to the quality or fitness for any particular purpose of goods, but goods must be fit for a particular purpose if the buyer has made known to the seller the particular purpose for which he needs the goods. The buyer relies on the seller's skill or judgment, and the goods are of a description which is in course of the seller's business to supply. Then fifth one, condition as to merchantability. If goods are bought by descriptions and the seller is a dealer in goods of that description, the implied condition is that goods must be of merchantable quality. This means that the goods must be saleable in the market under that denomination. The sixth one, condition as to wholesome ones. In case of eatable, the goods must be wholesome besides being merchantable. For example, milk. The last one, conditions implied by trade usage. The last implied condition is condition implied by trade usage. An implied condition as to quality or fitness for a particular purpose can also be fixed by the usage of trade. So these are all the implied conditions of the COS, contract of sale. The next topic, implied warranty. நம்ம implied conditions பார்த்தோம். இப்போ implied warranties. What are the implied warranties? Implied warranties, actually the implied quit, first one warranties is quit position. The buyer shall have any enjoy quit positions of the goods. The buyer shall have and enjoy quit positions of the goods if the buyer's positions is disturbed by a person having a superior right to that of the seller. The buyer is entitled to claim the damages. Then second one, warranty is free from any encumbrances. The goods bought must not have been subject to any charge or right in favor of a third party. If the buyer's position is disturbed by reason of existence of any encumbrance, he is entitled to claim damages for breach of warranty. Then third one, warranty in the cause of dangerous goods. Where the seller knows that the goods he is selling are dangerous or likely to be dangerous to the buyer, and the buyer ignorant of the danger, the seller should warn the buyer of the probable danger. Otherwise, he will be liable to compensate the buyer in case of any injury. Then, what are the rights of unpaid seller? Unpaid seller means a seller is deemed to be an unpaid seller when the whole of the price has not been paid, or a bill of exchange or other negotiable instrument given by him has been dishonored. If the seller has received only a part of the price, he is also an unpaid seller. Seller includes not only actual seller but also an agent of a seller or a consignee. Then what are the types of rights? What are the types of rights? First one, rights against goods. Then second one, rights against the buyer. The first topic, rights against goods. Where the property in the goods has passed to the buyer, right of line, right of stoppage of transit, right of resale. Then where the property in the goods has not passed to the buyer, withholding of delivery of the goods, right of line, stoppage in transit, and then resale. Rights against the buyer. Suit for price, suit for damages for non-acceptance, suit for cancellations of the contract before the due date, then suit for interest. The first one, right of line. Right of line. The first one, right of line. An unpaid right of line, right to retain the goods style till he receives the price conditions. Price conditions. Actually, the right of line means an unpaid seller has a right to retain the goods till he receives the price, but to exercise this line, he must have been sold without any stipulation so to credit, or where goods have been sold on credit, the terms of credit must have expired. It must be remembered that the right of line depends on the actual positions. It is known as the right of line. So first one, a seller must be in possessions of goods. Then second one, goods must have been sold without any stipulations as to credit, or where goods have been sold on credit and the terms of credit must have expired. You can also exercise the right of line when the seller becomes insolvent. Then third one, this right depends on actual possession, where the seller has transferred to the buyer the documents of title to the goods. His line is not affected so long as he continues to be in possessions of the goods. Then right of line when lost. When seller delivers the goods to a carrier other bailey for the purpose of transmissions to the buyer without reserving the right of disposal of goods, when the buyer or his agent lawfully obtains possessions of them, taken delivery from booking office, when the seller waives his rights of line. Then right of stoppage in transit, where the seller he delivered the goods to a carrier or other bailey for the purpose of transmissions to the buyer, but the buyer has not acquired them, then the seller can stop the goods and regain possessions. Goods must be neither with the seller nor with the buyer, but should be in the hands of a carrier. So further, the buyer must have become insolvent. So it is a right of stoppage in transit. Then right of stoppage in transit when goods termination. The termination of right of stoppage. The right to stop the goods comes to an end when the goods are delivered to the buyer or his agent, or when on arrival of the goods at the obtained destination, the carrier communicates to the buyer or his agent that he is holding the goods on his behalf of. Then it is the termination of right of stoppage. Then a right to resale. The right of resale. Right of resale. The unpaid seller can resell the goods. After exercising the right of line or stoppage in transit, even though he has given intimation to the buyer of his intention to resell, buyer has not tendered the price within a reasonable time, where the seller has expressing reserved the right of resale in the contract itself. This is the right of resale. Then, what are the rights against buyer? What are the rights against buyer? First one is suit for price. The ownership has passed, buyer refuses to pay, seller can file case. இங்கே பாருங்கள், suit for price means where the ownership in the goods has passed to the buyer and the buyer refuses to pay for the goods. The seller can file a case against the buyer for the price. Then second one, suit for damages for non-acceptance, where the buyer wrongfully refuses to accept the goods. The seller can sue him for damages for non-acceptance of the goods. Then suit for cancellations of the contract before the due dates. The buyer cancels the contract of sale before delay. Seller may either wait till the due date or can file a case immediately. It means where the buyers cancel the contract before the date of delivery, the seller may either treat the contract as continuing or wait till the due date, or he can file a case against buyer immediately. Then last one, suit for interest, where there is a specific agreement between buyer and seller regarding changing interest on the price. The seller can recover interest from the buyer from the due date of contract till the date of payment of purchase price. So specific agreement between buyer regarding charging interest on the price, buyer can recover interest from the due date to date of the payment. If there is no specific agreement, the seller can charge interest from such days as he may notify to the buyer. So it is known as the rights of an unpaid seller against the buyer personally. Then students, today we have learned about introduction, formation, then essential of contract of sale, what are the difference between sale and agreement, then conditions and warranty to sell the, then what are the different types of goods, transfer of ownership, conditions and warranties, implied conditions and implied warranties. Then where is a unpaid seller, what are the rights of unpaid seller and buyer? So these are all the above topics are completed in this class. So lesson is over. So students, understand this concept. I will give some assignment, complete it and send to me. If you have any doubt, please contact me. Thank you.